Okay, wonderful. Thank you, Ellie. So good afternoon, everybody, and welcome to today's HR Exchange Online. My name is Alex Herwood. I'm the Head of Employment and Solicitor at Bhayani Law. As you've just heard, Ellie is joining us today as well, and she's the Training Lead and Senior HR Advisor at Bhayani Law. So today we're going to be getting to grips with family leave. So just before we start, this is something that we are super proud of at Bhayani Law. We're currently in the top 2%, rated the top 2% in employment law for review with review solicitors. This is something obviously is a massive credit to the team, and we're very, very grateful to our clients for all the testimonials that they've provided. So on screen now, you can see a list of all the services that we provide. So we offer anything from recruitment right the way through to terminating someone's employment with any additional, with everything else in between and any additional bolt-ons that you might need, such as training and consultancy. Okay, so if you have any questions throughout this session, please just feel free to put them in the chat box and we'll aim to cover them as we're going through. If we run out of time, because we haven't got an awful lot of time today, please make a note of your question and email it to hello@bhyanilaw.co.uk and we will get back to you. Okay, so what will we cover today? On screen, you can see the bullet points of things that we're going to touch upon today. I'm going to start with an overview of statutory family leave, leading into the other points that are seen underneath this bullet point. All right, so as we have seen, as we know, the current system for family-friendly entitlement is already quite complex. It's important that we all know and recognise that further changes are on the horizon. The government has introduced a comprehensive review of the current systems in place that cover family-friendly leave. So this is running from 2025 through to 2026 and then into 2027. Sorry, there is a bee that just got, sorry. Just a wasp just came in through the window there, so I do apologise. Okay, so this review will form part of the wider Employment Rights Bill, which will aim to modernise the workplace rights and bring them in line with the realities that we face in today's workplace. Okay, so on screen, we can see a list of all the different types of family leave. You will see the first four, so maternity leave, adoption leave, paternity leave, and shared parental leave. These are the long-standing leaves. I don't intend to go through these in much detail. You can see from the slide, there's a little bit of detail there accompanying each different type of leave. What I intend to touch upon today is parental leave, emergency dependent leave, carers leave, and neonatal leave. All right, so parental leave then. So this type of leave is much different to shared parental leave. Okay, so it's an unpaid leave that allows up to 18 weeks per child, which can be taken before that child's 18th birthday. All right, this is capped at 4 weeks per year per child. Okay, so that's the maximum amount of time you can take per year. And it must be taken in week blocks. So you might have 1 week or 2 week. We can't take individual days unless obviously your employer allows you to do this or your child's disabled. Okay, so in terms of what a week is, a week equals the length of time that employee normally works over a 7-day period. So for example, if we have an employee that works 3 days a week, 1 week of parental leave will be equal to 3 days. If an employee works irregular hours or a regular week, the number of days in a week is the total number of days in a year divided by 52. So that's how we calculate it. So this kind of leave will be often exercised when we have parents that are trying to cover the summer holidays and they need 2 weeks out because they've not got the childcare, and that's when this kind of leave would kick in, or that's when that employee would ask for this type of leave. So in terms of emergency dependent leave, then, so this gives someone the right to take a reasonable amount of unpaid leave to deal with emergencies involving a dependent. All right. So what's a dependent? We know dependent can be a husband, wife, civil partner, child, parent, etc. It can even be a person who relies on you for care, like an elderly neighbour or something like this. Okay. So an example of when we might use this is if the child falls ill at school, a child falls ill at school, and we need to just quickly go and collect them. That's when we might the parent can leave to deal with the child. Okay. Carers leave then. So Ellie's going to touch upon this in a little bit more detail in a bit. This was introduced in 2024 and allows employees to take up to 1 week of unpaid leave to care for a dependent with long-term care needs. For example, elderly parent needs to be taken to a hospital appointment. We can exercise carers leave in these circumstances. And finally, neonatal leave, which was introduced from April of this year, provides up to 12 weeks of additional paid leave. So this is paid leave. This would be on top of the paternity leave. Okay, so this is where the mother might have given birth to a premature baby, and needs that additional time to look after that baby in neonatal. Okay. So eligibility and employers' responsibilities. So each type of leave has specific eligibility requirements. So they would link this to length of service, employment status, notice provisions. So first of all, with respect to policies, employers must ensure that their policies reflect the current statutory entitlements. Okay, really important. Legislation is updated regularly, we know, and policies can quickly go out of date. Just to give you a simple example, if an employer's handbook doesn't include the new carers leave entitlement introduced, then staff might wrongly believe they aren't entitled to it. This could give rise to grievances or potentially even claims. Second relates to communication. So communication is key with employees. We must make employees aware of their rights and responsibilities. This is essential. All right. So just to give a very simple example, if a manager fails to explain statutory maternity pay to an employee, they might assume wrongly that they're entitled to a year's full pay, when actually we know that they'll be only be entitled to the statutory 39 weeks unless there's a contractual provision for it. If they're not aware of this, this can lead to frustration, potentially, a bit of mistrust. So we just need to be so clear that we are communicating with our employees. Thirdly, we need to maintain employees' terms and conditions. Really important. When an employee is on leave, those terms and conditions are maintained, save for the exception of pay. All right. So this includes things like pension contributions, holiday accrual, continuous service, etc. So we need to ensure that those terms and conditions are maintained. Otherwise, we're potentially going to be looking at claims. Finally, really important, we need to avoid discrimination and detriment at all costs. Employers mustn't treat anybody unfavorably because of pregnancy or family leave. Okay. This is things as simple as, if a pregnant woman is out of the workforce on maternity, we've got to make sure that they are not overlooked for promotion, etc. This can give rise to claims. We really need to be on it in that regard. Right then. Okay, so this slide is discussing the interaction between the different types of leave. So this can be a very challenging area for employers, and it's so important that we can assist you if you need it in terms of how we manage it. So an employee, for example, may go on maternity leave and then partway through decide that actually they want to take shared parental leave. So this would then we would need to adjust the type of leave, the calculations, pay, etc. So it's really important that we get our heads around how to do that. What makes it more complex is that parental leave can be requested separately from maternity leave or paternity leave. All right. So what this actually means is that a pregnant woman could go on maternity leave, could then request parental leave, and then could, for example, then request that they take their accrued but untaken holiday. Obviously, this would be a big issue for the employer. It means that employees out of the business even for an even longer period of time. So we just need to be super careful that we know how to deal with these types of leaves. There we go. I mean, like I've just said, these situations are extremely challenging. We can help you with these. Please, if you have any questions, get in touch with us because, like I say, navigating it is a bit of a minefield. So now I'm going to pass over to Ellie, who's going to talk to us a little bit about carers leave. Thank you, Ellie.
Thank you very much, Alex. That's a really comprehensive overview of some of the different types of family leave. Don't forget, if anybody does have any questions, feel free to pop them in the chat and somebody in our team will answer them and get back to you as soon as possible. So Alex said, I'm just going to touch on a little bit more around the Carers Leave Act. This is one of the newer pieces of legislation that we've seen come in around family-friendly leave with neonatal as well. So I just wanted to give you a little bit more of an insight as to what this means, some key messages that we need to highlight, and then some practical steps for you as employers. So came into force last year, so April 2024. Employees now have a statutory right, as Alex said, to take 1 week of unpaid leave per year to provide or arrange care for a dependent with a long-term care need. The main aim here is to give employees flexibility and reassurances that they won't be penalised for meeting caring responsibilities. That was one of the underpinning reasons as to why a piece of legislation like this was implemented. Importantly, it's something that we need to remember, that this leave is separate from any of the family leave entitlements, such as the parental leave that Alex has just spoken to you about, and also the time off, the emergency time off for dependents. This piece of legislation sits as a completely separate and new piece of legislation which your employees have the entitlement to take. With that in mind, employers need to make sure that they've updated their policies, perhaps thought about training for managers so that requests for this type of leave are dealt with fairly and consistently. What I see all the time in my sort of day-to-day job of advising a lot of businesses on HR and delivering a lot of training is a lot of people misunderstand and misreport carers leave as sickness. And that, unfortunately, is something that we do have to consider as an organisation, where if somebody's telling you that they need time off to care for a dependent, or they need time off so that they can sort a situation out, whether that be the emergency dependence leave, or whether that be something that they can claim under the Carers Leave Act now, we have to be really careful that it's not misreported. One, because it would skew our figures, but two, it can also give rise to claims for our employees where they feel that we are detrimenting them and not allowing them their statutory rights to these types of leave. So just some practical steps for employers on carers leave. Make sure you've got a section in your family leave policy which covers this new provision here. If you don't have a carers leave policy, if you would like more information on this, please do get in touch. Please let us know. You can pop your email address into the chat function now, and one of our team can get back to you, or do contact us after. Train managers on how to recognise and handle these types of requests. It's really important to remember that they don't necessarily have to be made formally. They can be made informally, so they don't need to be in writing. So it could be as part of a supervision, it could be as part of a one-to-one, it could be as part of a telephone call that you're checking in with a member of staff. So please do make sure that we are recording these things and recognising and helping our managers to understand how to deal with them. Apply consistently, so please make sure you're applying these requests fairly to avoid any indirect discrimination against any different types of individuals who may have a protected characteristic, who statistically would be more likely to be a carer in a relationship. And then please just make sure that you're keeping a clear record of when carers leave has been taken, to ensure that you're managing those entitlements, but also just to ensure that we are not confusing them with sick leave and therefore misreporting from a system point of view. So I'm going to move on now to the Protection from Redundancy Act 2023. So this is a really important change which strengthens redundancy protection. Traditionally, employees on maternity, adoption, shared parental leave, they already had the right for priority for suitable alternative roles in redundancy situation, but this new act is extending that protection further. So what it's saying is the protection comes in from the point that the employee notifies you of their pregnancy and then up to 18 months after the child's birth or the adoption placement. The reason that it's 18 months is, as Alex showed you on that first slide that she put up on the screen, maternity leave, adoption leave, they last for a 12-month period. So an employee has the right to take 12 months off work. Of course, their pay entitlement during that period is slightly different, but they have an entitlement for 52 weeks leave. So that's your 12 months. And then they are now protected for 6 months after they return from their period of leave as well. Employers need to be extremely cautious when planning restructures, redundancy exercises that you might be going through. Getting that wrong can lead to discrimination, unfair dismissal claims. So it's a really tricky and challenging period to try and navigate around. Ultimately, how do we navigate around that? How do we protect ourselves? Plan ahead. Build protections into your redundancy processes. Make sure that you're documenting your decisions carefully. Okay, so when you're planning your restructure, build the protections into any selection matrices or timelines that you might be using. Keep records showing how alternative roles were considered and why certain decisions were made. Ensure redundancy letters, consultation scripts reflect the additional protections and the decisions that you've made. And finally, of course, please risk check things. Always run redundancy decisions through HR or a legal firm before you make the consideration, particularly if you do have somebody who has or who is on a period of leave, which is noted on the screen here, or who has recently just returned from a period of leave as well. Please make sure that you check it. So we've got a recent case law example for you here. So we're just going to go through a case that some of you may have seen pop up in the media more recently. So this was a case that was brought against a HR company, so Bright HR. So we're going to bring this to real life, with a real sort of case. I'm going to talk to you around it. And ultimately, one of the underpinning messages is, even if you're a HR professional firm, you are not protected against this stuff. You still make mistakes. So that's what this case looks into. So with this, there was a new mum who was returning from maternity leave, and she was moved into a lower earning role despite promises that her job would be protected. What actually happened is they dropped her income dramatically from £65,000 down to £24,000. So it's not just a tiny drop, it's really, really significant. When she raised the concerns, her manager actually brushed that off in what was described as an informal mum-to-mum chat. She raised a grievance. The company failed to deal with the grievance properly. They handled it poorly. They ignored the ACAS code of practice. And that resulted in a tribunal award of over £50,000 for discrimination and loss of earnings. So some of the lessons that I think Bright HR can take from this, and also other companies that are out there, other employers, is that employees have the right to return to the same role or a genuinely equivalent one. The reason I say the word genuinely equivalent or one that is similarly matched is because I think sometimes we say the role is equivalent, but actually is it? Have you looked at the terms and conditions? Have you broken that role down? Have you made sure that it is of like value, of like work? If you haven't, then it might not be deemed to be an equivalent role. Any reduction in pay, commission, bonuses linked to maternity leave do risk direct discrimination claims. So if you're awarding pay increases whilst you've got somebody on maternity leave, or if you're doing it when somebody comes back, just because they've been out of the business for a period of time, that doesn't mean that they shouldn't be considered as part of that process. The same with if they receive commission or bonuses throughout the year, they should all be considered. Just be really careful where we think we're having an off the record or informal conversation, because believe you me, they still carry legal weight. You might sit there and think, oh, it was just a quick chat, or oh, it was off the record, it was informal, it's fine. 9 times out of 10, they are admissible from a tribunal point of view, and they still carry quite heavy, significant legal weight. What you have to bear in mind is that the onus often falls to you as the company to prove that something didn't happen rather than the fact that it did happen. And the tribunal will always come to you and ask for evidence that you can prove, not necessarily the other way around. So please do just bear that in mind. Of course, I talk about this all the time, but if you do receive a grievance, please make sure that you deal with it properly. At a very minimum, you have to make sure that you follow the ACAS code of practice. So that is the minimum requirement for you. Some of you will have policies and procedures in place that outline what your grievance procedure will be. So it is okay at times to deviate away from ACAS and use your own policies and procedures, providing they hit those minimum standards. But please make sure that we are just following the ACAS code. If we don't, so if organisations don't follow the ACAS code of practice, when we are handling things like grievances in this particular case, the tribunal have the power to increase compensation by up to 25% for anybody who hasn't followed that process. So it's really, really important that you do follow that. So what are the real practical sort of takeaways for organisations from live cases like this, live cases? Return to work interviews. Make sure roles, pay, and terms aren't altered unless it's genuinely agreed between both parties. Make sure that you're having those return to work conversations with anybody who's taken a period of family leave from your business. It's quite a daunting time, I suppose, for anybody who goes on a period of family leave where they feel a little bit detached from the business. So ensuring that you are keeping in touch with them, ensuring that you are having those return to work conversations with them is really key so that they feel still part of the family, part of the company when they are returning from that period of leave. Make sure you train your managers, particularly around their language. You know, somebody might think mum to mum chat is acceptable, but facing a really difficult situation where you are potentially taking something away from somebody or making somebody feel that you are discriminating against them, phrases such as that would actually catch you and land you in hot water. So please train your managers around language. Avoid casual comments that can undermine employees' rights. That's a really, really important one to remember. Obviously, I've already touched on this, but have your clear documented processes around the grievance. You know, there's lots of training out there on how do you actually handle investigation? How should you deal with an investigation? What are the things that you should be looking for? Um, so look at that. Can you train your managers on how to handle these sorts of things rather than brushing them under the carpet? And then audit some of your risk areas. So if you know that you've got somebody who receives quite a lot of commission, bonus schemes, you know, think about role allocations post leave. Do they need to be reviewed? What are your processes that you have in place? Are you going to be undertaking a restructure in the next 12 to 18 months whilst somebody is on a period of leave? What does that look like? Have you got any provisions in place? Have you put any safeguards in place? Are there any risks for you as a business? Okay, that's really, really important. So I'm just going to go on to some practical strategies for employers. I have touched on quite a lot just from that case, but I think there's some really sort of key sort of headline things that you need to be considering when we're thinking about how to navigate and getting to grips with family leave. So make sure that you update your policies regularly. As we know, and you know, we've seen it happen many times throughout the years, employment law changes fast. If your contracts and handbooks are out of date, you're already on the back foot. So please make sure that you're getting regular reviews. Please keep your policies under this review. I tend to recommend a review of a policy either every 6 to 12 months. I know a lot of businesses that do them annually, and 9 times out of 10, that's going to be okay. Where there are significant provisional changes, the Employment Rights Bill is a big thing that is ever changing at the minute. We have a link on our website that you can have a look at. So you can go onto our website, you can follow the link, and you can keep updated with any of the changes that are happening with the Employment Rights Bill. I can't tell you how important that is, so that you can stay one step ahead of the game. Building new statutory entitlements such as your neonatal, your carers leave, your extended redundancy protections as they come into effect. So don't think, oh, I know about that, but our policy review isn't for another 12 months, so we'll do it then. Do it straight away. You don't have to only review your policies when your policy review timescale tells you that you need to. Make sure that you've got your clear, accessible policies, reducing misunderstandings, and it helps your managers to apply the rules consistently. So there's no good having a set of policies that nobody knows where to access. You need to make sure it's accessible. You need to make sure it's accessible for both your managers and your employees. So if anybody does have any questions, they can just look at that policy. Not only that, it stops some of the silly questions that you might get, or some of the, the questions that you think, oh, well, that's in the policy. If people have access to it, they can just gain a copy. They can go and grab that policy and have a little look. So training, of course, again, your policies are only as effective as the people that are applying them. Remember that. So frontline training, for your frontline managers often requires sort of a lot of in-depth thinking around. So think about giving them training on what's the leave, how does it apply, flexible working requests. So with every type of situation at work, employees do have the right to request flexible working to their working environment, their working hours, their working situation. Your managers need to know how to handle those requests. It's not good enough anymore just saying, no, sorry, we can't implement that. We have to follow a process. We have to consider it properly. If they don't know how to do that, consider getting them some training or looking at sort of our future HR exchanges on these sorts of things to see if any of them can come along, and then think about, do they know how to raise, do they know how to deal with a grievance, those sorts of things. Regular refreshers build confidence. They reduce the risk of mistakes. So please just bear that in mind. Keep clear records, even if it isn't written down. Well, what I hear all the time and what I say all the time when I'm delivering training, if it isn't written down, it didn't happen. And that's one of my absolute golden rules. I can see some of my regulars on here and those that I've spoken to before, and you will have all heard me say that several times. HR golden rule: write stuff down, maintain accurate records of absence, leave, pay entitlements, calculations, notes from consultation meetings, investigation meetings, grievances. Good records protect the business in disputes. They support fair treatment, and they provide valuable data for when you're thinking about future workforce planning or when you're looking at certain situations. And then the last two on here, so fostering a supportive culture. Legal compliance is the baseline. Culture is what makes people stay within your organisation. So a supportive approach means that employees are less likely to escalate issues into grievances and complaints. A culture of openness encourages early problem solving. It strengthens retention across your business. I cannot tell you how important the culture is, making sure that the underpinning nature of that is really spot on. And then, of course, that last one on there, it's always better to ask than it is to guess. So if you have got a really complex situation, so where Alex talked about the overlapping of leave, so somebody changing a period of leave from maternity to shared parental or vice versa, if you've got any restructures that you're going through, allegations of discrimination, all of these things can carry quite high risks for businesses if not navigated and managed properly. So please seek some advice. You have internal HR, a short consultation with HR or legal experts can prevent costly mistakes. Consider setting up relationships with trusted advisors to give managers quick access to support. That is a really key thing that you can do to support your business. Okay. So just some additional things that you might want to consider is consistency is key. Communication matters. Um, Risk assess your decisions and have proactive engagement. They're my 4 sort of practical top tips when you're thinking about practical strategies and how to navigate through. So when we just sort of move on to um, how the Employment Rights Bill will change family leave and what is to happen with this. So for those of you that don't know, the Employment Rights Bill is the government's next big step in strengthening family-related workplace practices. It builds on recent changes that have been brought into place, that Alex and I have spoken to you about today, but it is looking to go a little bit further. We need to be ready for stronger dismissal protections, new statutory rights, and how that's going to affect how we manage our policies, our leave, and our workforce planning. So some of them are just listed here for you on the screen, but the wider protection from dismissal. So under the bill, that's going to extend dismissal more broadly. It's going to look at covering pregnant employees or those returning from family leave. Sort of further detail will come after the consultations that we're going to see in autumn this year. But employers need to anticipate a higher bar for dismissal protected, a higher bar for any dismissal of protected employees, and more scrutiny around capability, conduct, performance-related dismissals during protected periods of employment. So a practical point for you is start reviewing your processes, your policies, your dismissal procedures now. Ensure that decision making is well documented, alternatives are considered, and HR oversight is built in. Of course, we have the day one rights for paternity and parental leave. So currently some of the entitlements require that qualifying period of service. The bill's looking to remove that altogether. So from April 2026, we're expecting to see day one rights, and then flexibility. So paternity leave will no longer be lost if taken before shared parental leave. So that's how we'll likely see things change. So again, from a practical point of view, new starters could all immediately qualify for these rights. So update your HR systems, make sure your onboarding processes are up to date, have policies in place so that managers don't wrongly reject requests off the back of stale and outdated knowledge that they have. Statutory bereavement leave. So one of the most significant cultural changes is around bereavement leave that the government are currently looking at. And whether it will be at least 1 week of unpaid bereavement leave and whether that will become a statutory right. So the consultations in autumn 2025 are going to confirm what relationships are going to be covered and how the leave can be taken. So again, as a practical point, businesses need to prepare for a wider uptake of bereavement leave than is what's currently seen with your discretionary policies or your compassionate leave policies, because it'll now be a statutory right rather than discretion or whatever your compassionate leave policy says. We do have protection at the minute around an individual who suffers a miscarriage, but they're looking to go slightly further with that. So there'll be a statutory right for miscarriage-related bereavement leave. So it covers the loss of a child before 24 weeks of pregnancy. The implementation date is not confirmed yet. It's expected after the wider sort of bereavement leave right has come into place. So again, sensitivity, confidentiality is going to be crucial. Train your managers on how to deal with these requests empathetically while also respecting employees' choice around disclosures. That'll be a really, really important thing for you. So just some timelines. We've got some changes coming in April 2026. So the day one rights, the unpaid parental leave, we're starting to see that sort of creeping in. April 2027, we might see some additional sort of rights around the statutory bereavement leave. And like I said, around the miscarriage-related bereavement leave, we don't have any dates of yet. So it's important to remember it's not happening overnight, but the direction of travel is really clear. Family leave protections are becoming broader, stronger, and more flexible. So what do you need to do? Review your policies, update them, reflect the changes that have already come into place. Build in training around sensitive conversations, handling leave requests. Start thinking about workforce planning. More rights means more periods of absence to cover. So you'll need to think about that from a headcount point of view. Engage with consultations, look at, engage with the consultations the government are doing. What does it look like? What's going to happen? And above all, please just remember, beyond the legal compliance, how you handle your family related leave speaks volumes about your culture and value as an employer. I cannot tell you how important that is. So that's one of the most important things that we do need to remember. So we are now going to go into a little bit of a breakout room with the attendees that we've got on today's session. So in our breakout rooms, we're going to spend roughly between 5 to 10 minutes in those rooms. You will have Alex and I in either of your breakout room where we will lead you on the discussions. The conversations that we're going to have with you and the questions that we'll be asking is, what key challenges around family leave have you faced in your organisation, and what actions could you take after today to strengthen the compliance and support your employees off the back of what Alex and I have been through with you there and spoken to you about. So we are going to break out into our sessions now. Like I said, between 5 to sort of 10 minutes, if everybody can just make sure they are back just before 10 to 1, just so that we can look to close off today's session. I hope you've enjoyed everything so far, but please feel free to talk openly in the breakout rooms because they are not being recorded as part of this session, so we can have an open conversation about these two questions on here. Okay, so whoever's in my room, I will see you in a short minute.
Thanks, Ellie.
Given family leave can be quite a sensitive subject, we are happy for you to send us an email after today's session if you would prefer to pick up with either Alex or I separately. The email address is hello@bhayanilaw.co.uk, and one of my colleagues will just pop that in the chat box for you now so that you can see that if you were to need to contact us at any point. So does anybody have any burning questions, anything that you want to ask? I don't believe anybody does, but like I said, if you do have any questions at any point, then please do just feel free to drop them through to our main email address. So just in terms of just closing off the session and how we can help, some of you will know already as you are our existing clients, but for those that don't, we do offer outsourced support plans for organisations to support them navigate through really difficult periods of time like this. So there's a little bit of information on the slide here for you. If you would like to find out more information, then please do go online, have a look, contact one of us, and we will arrange a meeting with you and discuss how we can support your business to navigate through any difficult HR situations or queries that you might have. We've got some client testimonials on the screen for you there. As Alex said, we were recently placed in the top 2% for employment law and HR advice by review solicitors, which we are so proud of. We work really hard with our clients to keep that reputation. And, even though we do say it ourselves, we're good at what we do. So please do contact us if you need anything. We have got some more webinars like this coming up. So Alex and I will be delivering a session on preventing sexual harassment, lessons learned and the road ahead next Wednesday. That again will be over lunchtime. We'll be looking at what the piece of legislation brought into play, the changes that we've seen happen over the last 12 months, and actually what the government are doing going forwards and how that might change. And then we also have a HR forum, which is taking place in October, which is around neurodiversity in the workplace and embracing inclusive practices. That is run through the Doncaster Chamber. It's free to their members, but for anybody who isn't a member, there is a slight signing up fee on that. So you can look to register for that. Outside of that, we deliver sort of practical HR training tailored to your organisation on a variety of topics. So if you've decided the process is a little bit of a sticky point for us and we're worried about the language that some of our managers might be using, or we're worried about their ability to apply certain periods of leave or misreporting or miscommunicating what leave that might be, or just quite simply not writing things down, please do get in contact with us. We can support your organisation and put together a training plan that's bespoke for you, for your managers, in order to help you navigate through really challenging times and changes in employment law legislation and what's to come. There's just a QR code here. You can sign up for our free monthly newsletter that does go around. We share legal updates on there. So anything that's changing around the Employment Rights Bill, that's in our newsletter. We share any recent sort of case law stories that we've seen or any HR hot topics that you need to consider, as well as our events and training that we have coming up over the next couple of months. We do ask for participants to undertake a feedback form and a feedback after today's session, apologies. So feedback forms will be sent to you. If you complete the feedback form, you can request a copy of the slides and they will be sent to you. If you have enjoyed today's session, please feel free to go on to Google, Trustpilot, Review Solicitors, leave Alex and I and our team a review around the session if you found it useful. On the feedback form, you can pop in there any future topics that you would like to see. So we deliver our HR exchanges once a quarter. If you've got any burning topics and you think I really want to know more about that, let us know and we'll most certainly put that on and deliver it to our client base. So the last thing from me is just thank you so much for listening. Thank you for coming along to today's session. We hope you found it useful. And if you do have any questions, please don't hesitate to get in touch. Okay. So thank you very much, everyone.
Thank you very much, Ellie. Thank you, everyone.
So we'll now bring the session to an end.